The Supreme Court just dropped a 6-3 ruling that is already rewriting the future of every firearm law in America. And if you own a gun, live in a restrictive state, or simply care about constitutional rights, what happens next directly affects you. Hit subscribe and turn on notifications because this is one legal battle you cannot afford to miss. What the 63 Supreme Court decision actually music says. The Supreme Court's 6-3 ruling landed like a constitutional earthquake across every level of American firearms law. Music and the shockwaves are still spreading. 6 justices aligned behind a majority opinion music that doesn't just resolve one narrow dispute. It systematically dismantles the legal architecture that anti-gun states have been building for decades. What separates this ruling from every prior Second Amendment decision is the precision and intentional clarity of the majority's language, music, deliberately written to eliminate the gray areas that lower courts have exploited since Heller in 2008, music, and Bruen in 2022. According to federal court records, lower courts issued over 200 Second Amendment decisions, music, between 2022 and 2024 alone. And a significant portion of those decisions, music, found creative ways to uphold firearm restrictions despite Bruin's demanding historical framework. This ruling was written specifically to shut that pattern down. The 63 margin itself sends a structural music signal. Unlike a fragile 54 decision, a 6-justice majority doesn't need internal compromises that weaken the core holding. Meaning this president arrives fully intact with maximum constitutional force music and with enough ideological durability to survive the next several court terms without serious risk of being quietly reversed or narrowed from within. And make no music mistake, when 6 justices speak this clearly, and this unanimously, on a constitutional music question, every lower court judge in America is legally obligated to listen, whether they personally agree with the outcome or not. Legal historians tracking Supreme Court Second Amendment decisions, music, are already calling this the most consequential firearms ruling since Heller itself. And the full weight of what this majority just set in motion will be felt in American courtrooms, state capitals, and gun music shops for decades to come. Key legal arguments behind the majority opinion. Music. The 6 justices who formed this majority didn't just vote together. They built a legally airtight argument that future courts will find extraordinarily difficult to work around. And understanding that argument is the key to understanding why this ruling hits so much harder than anything music that came before it. The majority's first and most powerful move was rejecting the government's reliance on interest balancing entirely. Music slamming the door permanently on the idea that a state can justify a firearm restriction, music, simply by saying it makes people safer. Because under the Constitution, good intentions, music, don't override fundamental rights. Their second major argument leaned on a critical historical fact that gun control advocates rarely want to discuss openly. Music. At the time, the Second Amendment was ratified in 1791. There was virtually no American legal tradition of banning entire categories of commonly owned firearms from law-abiding citizens. Music. And the majority held that this historical silence speaks louder than any modern policy argument. Music. A landmark legal study from Georgetown Law found that out of over 1,300 firearms regulations examined from the founding era through the 19th century, music fewer than 3% involved outright categorical bans on weapons in widespread civilian use. Music, meaning history, is overwhelmingly on the side of gun owners, and this majority used that data as a constitutional hammer. What this majority essentially told every anti-gun legislature in America is brutally music simple. If you cannot find your restriction written into the fabric of 1791 American history, your law does not survive. And no amount of modern political pressure changes that constitutional reality. Music. Perhaps most significantly, the majority also addressed the common use doctrine head-on. Music reaffirming that any firearm owned by millions of law-abiding Americans for lawful purposes sits at the absolute core of Second Amendment protection music and cannot be categorically banned, regardless of how dangerous a state government claims it to be. Why the dissenting justices' music strongly disagreed. The three justices who dissented didn't just disagree with the outcome. Music. They argued that the majority's entire approach to reading the Second Amendment is dangerously disconnected from the real world that ordinary Americans actually live in, and their dissent, music, was sharp, emotional, and backed by numbers that demand attention. The dissenting justices pointed to a sobering reality. According music to the Centers for Disease Control and Prevention, firearms are the leading cause of death for children and teenagers in the music United States, surpassing car accidents since 2020. And from their perspective, a constitutional music framework that makes it harder for elected governments to respond to that crisis is not protecting freedom, it is enabling tragedy. Their core legal argument was that the majority's rigid reliance on 1791 historical tradition, music, is fundamentally flawed because the founding era had no AR-15s, no 30-round magazines, and no weapons capable of killing dozens of music people in seconds, meaning you simply cannot look to 18th century history to regulate 21st century firepower. The dissent further, music, warned that this ruling will trigger a flood of litigation that clogs federal courts for years, while dangerous weapons remain on streets during the legal music battles. What makes the dissent particularly striking is that all three dissenting justices signed on to the same opinion, music, rather than writing separately. A rare show of unified opposition that signals just how deeply and fundamentally these two legal visions of the Second Amendment are in conflict with each other. The dissenting justices also, music, raised a pointed institutional warning that should not be dismissed lightly, that a Supreme Court willing to strike down democratically enacted safety laws based on 18th century music historical analogies is a court that is prioritizing ideological consistency over the lived safety realities of 330 million Americans who are alive right now in 2025. Music, not in 1791. So here's the question for the comments. Music. Do you believe the Constitution should be interpreted based on 1791 history, or should it evolve to reflect modern realities? How this ruling music impacts federal firearm regulations? This ruling doesn't just shake up state laws, it sends a direct shockwave straight into the heart of federal firearm regulations, music, that millions of Americans interact with every single day, and the practical consequences of that impact are bigger than most people currently realize. Music. The federal government currently enforces over 20,000 firearm-related laws, rules, and regulations across music various agencies, including the ATF, the FBI, and the Department of Justice. Music. And a significant portion of those regulations were built on the exact legal foundation that this 63 majority just cracked. The ATF alone has issued more than 100 regulatory actions affecting gun owners since Music 2021, covering everything from pistol braces to solvent trap kits to ghost guns. And virtually every single one of those regulatory actions is Music, now sitting in a legally vulnerable position because they were justified using the interest balancing approach that this ruling explicitly buried. According to a 2024 Music Cato Institute analysis, approximately 47% of currently active federal firearms regulations lack a clear historical analog from the founding era, music meaning they cannot survive the tightened standard this majority just enforced. That number represents hundreds of specific rules affecting music, how Americans buy, own, carry, modify, and transfer firearms. And plaintiffs across the country are already lining up to challenge every single music, one of them using this ruling as their constitutional ammunition. What that means in plain language for the average gun owner is that federal agencies like the ATF music are about to face the most legally exposed period in their entire institutional history. And the challenges coming their way are backed by music, a Supreme Court majority that has already shown it has zero tolerance for regulatory overreach that cannot survive historical scrutiny. Consider this staggering fact. The ATF's annual budget for firearms regulation enforcement currently exceeds $1.7 billion. Music. And a significant portion of that taxpayer money is now being spent defending regulations that this 63 ruling has rendered constitutionally indefensible music, under the very legal standard the Supreme Court just reaffirmed, and sharpened what it means for state-level gun restrictions. If you live in a state with strict gun laws, this ruling just changed the legal ground beneath every single one of those restrictions, and the consequences for state legislators scrambling to defend their firearms regulations right now are more serious music than any headline is currently capturing. According to the G. Ford's Law Center, which tracks firearms legislation across all 50 states, there are currently more than 300 active state-level gun restrictions, music, spread across 27 states that directly conflict with the historical framework this 63 majority music just reinforced, meaning more than half the country is sitting on a mountain of firearm laws that are now constitutionally exposed and legally, music, vulnerable to challenge. States like California, New York, Illinois, Maryland, music, and Massachusetts have built entire layers of firearms regulation on top of the interest-balancing approach that this ruling music permanently discarded, and those layers are now legally unstable from the foundation up. Music. A 2023 report from the National Shooting Sports Foundation found that states with the most restrictive gun laws, music, average 47 separate firearm regulations per state, each one of which must now survive the demanding historical analog test that this majority tightens significantly. For everyday gun owners in those states, this ruling is the most important legal development in their lifetime, because it transforms their constitutional rights from theoretical promises, music, into enforceable legal guarantees that state governments can no longer casually override with a simple legislative majority. The brutal reality for anti-gun state legislators is that they spent years carefully constructing their restrictive firearms frameworks. Music. And this 6-3 ruling just handed Second Amendment attorneys a constitutional wrecking ball powerful music, enough to bring those frameworks down one statute at a time, adding even more pressure to that already explosive situation. Music. A recent survey conducted by the Firearms Policy Coalition found that over 68% of gun owners in highly restrictive states are now actively aware of this ruling and are already in contact with legal advocacy organizations about challenging the specific restrictions that affect them personally. Music, a level of organized legal mobilization that state attorneys general have never faced at this scale before. Perhaps the most music-telling sign of just how seriously restrictive states are taking this threat is that California, New York, and Illinois have already quietly begun allocating additional emergency legal defense funds, specifically to protect their most vulnerable gun restrictions from the wave of constitutionally empowered challenges that this 63 ruling has already set into motion. The Department of Justice's next legal move. The Department of Justice is not sitting quietly after music this 63 ruling. It is actively recalibrating its entire music legal strategy around firearms enforcement. And the moves it makes in the next several months will determine whether this ruling transforms American gun law in practice or gets music slowly suffocated by federal bureaucratic resistance. The DOJ currently oversees a firearms enforcement music budget that exceeded $120 million in 2024, funding hundreds of federal prosecutors, ATF agents, and legal music teams whose entire professional infrastructure was built around the regulatory framework this ruling just fundamentally challenged. According to federal court filing music records, the DOJ was actively defending more than 80 separate firearms-related cases in federal courts across music multiple circuits as of early 2025. And every single one of those cases must now be reassessed, music restructured, or potentially abandoned in light of the new constitutional standard this majority established. Music. Legal analysts tracking DOJ response patterns after major Supreme Court decisions note, music, that following the 2022 Bruin ruling, the DOJ took an average of 14 months before meaningfully adjusting its litigation posture, suggesting that gun owners should expect a prolonged period of legal turbulence before federal enforcement practices actually align with what the Music Supreme Court just decided. The critical question the DOJ must now answer publicly, music, is whether it will respect this ruling genuinely or find creative ways to work around it. And history strongly suggests that the answer to that question will not, music, be straightforward, clean, or quick. A particularly revealing data point is that music since 2008 and the Heller decision, the DOJ has spent an estimated $340 million in taxpayer funds defending firearms regulations in federal courts. Music. And a substantial portion of that legal spending was directed toward defending the exact type of interest-balancing justifications that this Music Supreme Court majority has now permanently and decisively rejected. What makes the DOJ's current position even more politically complicated is that the current administration's public stance on firearms restrictions, music, is now in direct constitutional conflict with what 6 Supreme Court justices just music declared to be the law of the land, creating an institutional tension between executive branch firearms policy and judicial branch constitutional authority that has no easy or politically painless resolution. So, tell us in the comments, do you trust the Department of Justice to honestly enforce this Supreme Court decision? How this decision connects to previous landmark music gun cases? This 63 ruling did not arrive in a vacuum. It is the latest and most powerful chapter in a constitutional story that music has been building for over a century, and understanding how it connects to the landmark cases that came before, it reveals exactly why this moment feels so historically significant to everyone paying close attention. The Supreme Court's modern Second Amendment journey effectively began with District of Columbia versus Heller in 2008, where a 5-4 majority first established that the Second Amendment, music, protects an individual right to keep and bear arms completely separate from any militia service. A ruling so consequential that legal scholars from Harvard Law School, music, described it as one of the most debated constitutional decisions of the entire 20th and 21st century combined. Then came McDonald versus City of Chicago in 2010, which extended that individual right protection against state and local governments, not just federal ones. And according to court records, McDonald immediately triggered more than 400 new Second Amendment legal challenges filed within just 18 months of the decision landing. Then, Bruin arrived in 2022 and replaced the balancing test entirely with the historical tradition music framework. And now, this 6-3 ruling has taken that framework and sharpened it into the most precise constitutional tool music Second Amendment advocates have ever had, creating a direct and unbroken legal line from 1791 straight to today's courtrooms. What you are witnessing right now is not just a single court decision. It is the culmination of nearly 2 decades of carefully built constitutional precedent. Music finally reaching the level of clarity and force that Second Amendment advocates have been fighting toward since the very first post-Heller music challenge was filed in 2008. A critical piece of historical context that makes this progression even more remarkable, music, is that between 1939 and 2008, a span of nearly 70 years, music, the Supreme Court, issued exactly 0 major Second Amendment decisions protecting individual gun rights, meaning the entire modern framework of Second Amendment protection that gun owners rely on today was built in less than 17 years and is now culminating in this landmark 63 ruling that may well define the constitutional boundaries of American firearms law for the next half-century. What that 70-year silence followed by this rapid and powerful succession of pro-Second Amendment rulings tells every serious legal observer is that the Supreme Court has undergone a fundamental and music-durable philosophical transformation on firearms rights. And this 63 decision is the clearest music and most forceful expression of that transformation the court has ever delivered. What gun owners and lawmakers should expect music next. The moment this 63 ruling was handed down, a countdown clock started simultaneously in Curtis's, state legislatures, and federal agencies across the entire country. And what happens during that countdown will directly affect every single gun owner and every single lawmaker who has built their political identity around firearms policy. According to a 2024 Duke Center for Firearms Law report, there are currently more than 150 active Second Amendment cases, working their way through various federal circuit courts right now. And every single one of those cases, just got a brand new and significantly more powerful legal argument injected into it, courtesy of this ruling. For gun owners specifically, the most immediate practical expectation is that certain challenged restrictions, in their states, may begin falling faster than at any previous point in Second Amendment legal history. With some legal experts privately estimating that up to 70 federal court decisions, currently upholding various firearm restrictions, could be reversed or reconsidered within the next 24 months directly because of this ruling's tightened standard. For lawmakers in restrictive states, the expectation is equally dramatic, but in the opposite direction. Legislative council offices in states like California, New York, and New Jersey are already working overtime auditing every existing firearm statute against the new constitutional standard, knowing that defending legally exposed gun laws in court now costs states an average of $2.3 million per major case, according to National Conference of State Legislators data. The bottom line for both gun owners and lawmakers is the same. The legal and political landscape around firearms in America, has fundamentally and permanently shifted. And anyone who is not actively preparing for the consequences of that shift right now, is already dangerously behind. Gun rights organizations, including the Firearms Policy, Coalition, the Second Amendment Foundation, and the National Rifle Association, have all publicly signaled that they are treating this ruling as a generational legal opportunity and are actively accelerating their litigation pipelines, to file new challenges. While this ruling is fresh, maximally applicable, and backed by a Supreme Court majority that has demonstrated it is fully prepared to enforce the Second Amendment with the same seriousness and constitutional force, it applies to every other fundamental right in the Bill of Rights. According to internal legal strategy documents reviewed by firearms law analysts, Second Amendment advocacy organizations have collectively budgeted over $45 million specifically for post-ruling litigation in 2025 alone. A level of coordinated legal investment, that virtually guarantees this 63 decision will be tested, expanded, and applied in courtrooms across every state in the country before the end of the current Supreme Court term. This 63 ruling has lit a constitutional fuse, that is burning through every level of American firearm law simultaneously. And the explosions are just getting started. Drop your thoughts in the comments below. Share this video with every gun owner you know. Hit that like button and subscribe so you never miss a critical update.